So where do we see the first appearance of specifically like a library archive exemption?
The first one? Library of Alexandria? I mean, we can go that far back if you'd like, where everything that landed in the port, the officers of the Egyptian government would go on board, not even look for, illegal cargo, look for books and scrolls, bring it back to the library, copy it, and then return the original to the owner. I mean, that's how far back archiving goes. I mean, that's a very long-term vision of it. But conceptually, that was the beginning. The idea, there's an illusion, some historians have discovered maybe that they didn't necessarily give back the original. They gave back the copy. Now, I've only recently read that, so I don't know if that's true or not. But as we know, that would be a shame because that means the original burned with the Library of Alexandria. But the idea is that, yes, that's the earliest, I guess, inception of that. But for our purposes here in the United States, there was the concept of libraries and archives having an important role as reflected in Copyright Acts prior to 1976. But to be honest, that moment in time, that act being passed, which is the law by which we are governed today in the copyright arena, that's where 108 really came to fruition as we're capable of doing these things for preservation purposes. Conceptually, had we borrowed this from other countries? Well, yeah, in the same way we borrowed a lot of ideas regarding our laws and governing from England, the UK, etc., because we were once a colony up there. But again, there was a French deposit law that also existed prior to our 108. And the idea in Europe of national deposit is something that feels like it has an archive basis to it. So if you guys are not familiar, there are laws in other countries, such mainly in Europe, that require that you deposit something in a national library, a copy of a book, a copy. And that is very much an archiving function as much as it is a cultural heritage, preserving function that exists there. And so those have been around for a long time. But again, what we can do here in the U.S. with 108 is not necessarily just keeping. We can also share. Your library had a copy that burned, we can send you one. You had one that was stolen, we can make a copy and send you one. There's a narrow circumstance by which we can exercise those rights. But they are important to kind of our goals. Kenny Cruz's report on 108 versions across the world found so many examples. I can't even get into how many, but ups and downs, lefts and rights. Some countries were resistant to that type of a right. They weren't sure how it would impact the publishers. Some countries embraced it wholeheartedly, as we did here in the United States. Some countries viewed it as a mechanism in which to ILL everything instead of having your own collection, and they want to avoid that. So there's been interesting pressures economically throughout the world that has affected that type of right. Now, even here in the States, we want to do something else with 108. There's the 108 study group, which was established years ago, which had a lot of recommendations about, how do we deal with technology and our 108 archive copies or our preservation copies? What is, within the walls of the library or within the geographic borders of the library, is a pin wall within the library now? Is a server within the library? Or, because on the grounds or in the space of the library has changed dramatically. But that's not reflected in the current act, but it's reflected in the current thinking. Another aspect of 108 and where we want to get our partners in the museums involved is that libraries and archives have these beautiful 108 exceptions. Museums do not. And that's a real problem, I would say. And the 108 group, among other things, also recommended that. Like, why should we not include museums here?
How does that play out for entities or organizations where the line in terms of what they are? I mean, do organizations explicitly register as special collections libraries or other things instead so they can avoid that?
Yeah, well, so the idea is like, what if I'm an archive inside a museum? Yeah. What does that mean? I am hard pressed to think there's an answer for that. But, you know, what if there's a museum? I've been to a library where there's a museum inside the library. What does that mean? You know, that's the opposite problem. That's what I'm saying. That's what we want to avoid. And be like, well, technically you're registered as a library, so you can have these rights. Or technically you're a museum and you take fees at the door, so therefore you're a museum, even if you have a specialized library inside a museum. Now, many rules regarding archives and access and 108 copies for preservation and such ask that it at least be open to the public, right? The intention wasn't necessarily to serve private archives or private libraries, although they can be served in that regard to a certain extent. But more often than not, the rule has a beginning kind of preamble on a lot of the different sections of 108 that basically says, you know, it should be an archive that's open to the public. That's one of the things. Now, as you know, Harvard, we have swipes at the gates at some of our libraries. However, absolutely, you can fill out a form and get access. So as long as you are open to the public, are open to researchers, what I think the Congress was thinking of is a private archive that's only open to people that can't, like, you know, not allowing even researchers to come in. We have very, very closed, top secret archive. I'm not aware of anyone that operates like that currently. Most people let in outside researchers that want to study their topic, but I don't know, maybe there's a secret society, Skull and Bones. Archiving and also, you know, some kind of mission to allow, you know, our culture to thrive and save and be preserved and be studied. So I don't think they're that far off from us.